dispute as to it. So I'm going to set this for a non-jury trial, July 1, 2025, 25 at 9 a.m. That's an in-person hearing, so you'll need to be here, ma'am. And they'll have to have somebody
And we're
show me
live.
either
Live,
that
live,
there's no
live.
lease or you'll have to show me that there's a lease. But then I'll make a decision on it,
Absolutely.
okay?
Okay. Also, I'm also leaking out legal help, legal representation.
All
So,
right. That's fine. You can have legal representation come with you on that date, but I'm going to set it for trial on that date.
thank you so very much. And you have a
Thank
beautiful
you.
day. Thank you so much.
You do the same.
Okay,
Apartments
get
versus
started on this
Regina
thing, I guess.
Avenue.
Put the coffee away.
She's here. She stepped out.
Oh, let's draw a coffee filter and see
Strong
what
Future
happens.
Homes versus Lolita
Coffee
O'Day.
filter? Yeah, I guess.
Lolita O'Day. Where is she?
She's outside. Talking to legal services.
Pop out some chat.
Court calls the case Strong Future Homes versus Sajidra.
Pop out some chat.
I got that right.
Landing for plaintiffs.
Hello, your name?
My name is Ciatra Moore.
Ciatra Moore. Okay, I messed it up. Why are you laughing? Why are you laughing? Look at how it's spelled. I mean, it actually is spelled exactly as she said it. However, not where I would put I wouldn't break the name apart that way. Anyway, all right. I apologize.
It's okay.
All right, what's the plaintiff's claim on this case?
I have a balance including court costs of $560.
All right. And ma'am, how are you intending on getting that paid?
If I can, I would like to pay it by the end of the month.
Okay. When you say by the end of the month, what day can you?
I can pay it by the 30th, but I get paid on the 25th. But I just want to give myself some grace.
All right. Well, okay. If you get paid on the 25th, can you get it paid by what time were we set to? By say noon on the 27th?
Yes.
Can you get it paid by then?
Yes.
Because if you get it paid and they know, then the case can get dismissed.
Okay.
Okay.
That's fine.
Let's see.
So I'll adjourn it out to the 27th, 2025 at 2 p.m. You'll get that paid before noon.
Well,
Yes. And I have to here. Can I pay online? I have to.
So you can't.
How you normally would pay.
You paid, yeah.
Okay.
If you can pay it on the 26th, that would be even better.
Okay.
Yeah.
If possible, because then they'll just ledger.
Okay.
And hopefully it'll be dismissed and you don't have to show back up.
Okay.
And then I don't have to try to butcher your name. All right.
Thank you.
Thank you.
Have
Thank
a
you.
great day.
Court calls case Strong Future Homes versus Jamie Kaiser.
Jillian Engen for plaintiff.
Good afternoon, Your Honor. Andrew Camp on behalf of the defendant. Judge, today I filed an answer affirmative defenses in an appearance, and for the record, I'm personally handing a copy to opposing
Where was
counsel.
that filed?
That was filed
Filed that today?
Yes, Your Honor.
That's right.
And Judge, I do request a week to file a counter complaint. There is a cause of action under the Regulation of Collection Practices Act because this debt's been paid already. And it's pursuant to a previous case that you signed a
Now,
condition.
if it's been paid, then why can't you just work that out?
Well, we can, but
File what you want to file. June 27th, 2025. 2 p.m.
okay, I'll file that counter complaint within a week, Judge.
Well, do what you're gonna do.
Thank you.
Court calls the case of Strong Future Homes versus Alana Lindsay.
Jillian Engen for plaintiff.
What's wrong, ma'am? Were you trying to get our attention?
Yes, they call her case. Regina Agnew. I had to go to the restroom. You know, you make me so nervous.
Whoa, whoa, whoa. I made you nervous? No, oh, in a good way. Oh.
Let my neighbor that I'm sitting by know that if they call my name, I have to go go to the restroom.
You know what? I knew it was you, so I waited for you to walk out, and then I called. No, I'm kidding. I'll call you back up momentarily, man. Strong Future Homes versus Lindsay. Your name?
Alana Lindsay.
All right. Where are we on this case?
Your Honor, I have a balance including court costs of $486.
All right. You were gonna get that paid. That's what you
Yeah.
told the court last time?
I just haven't got paid yet. The last court date was like last Friday, and I get paid every 2 weeks, so it just hasn't happened yet.
Okay. So when do you get paid?
Wednesday.
This upcoming Wednesday?
Yes.
Okay. All right. So it said you're gonna pay it in full by next week, but maybe that, okay. But I wasn't the judge on the case. So here's what I'm gonna do. I'll adjourn it to June 27th, my next date, 2025 at 2 p.m. Okay? Get that paid. All right. And then you don't have to come back and see me, so I
Okay.
don't make you nervous.
Thank you.
You're welcome. I said it. Yeah, I said that for you. Strong Future Homes versus Charles Ellison.
Jillian Inges for plaintiff.
Mayor, can you hear me?
Hello, what's your name, sir?
Charles Ellison.
That's
All
even
right.
right. Wow, I'm
Just turn it.
impressed.
There you are.
Okay.
All right, where are we on this case?
That
Your
was
Honor,
surprising.
we're requesting to adjourn to the next hearing date. My client's doing some recalculations on the ledger.
All right. You have any objection to that, sir?
No, sir.
Okay, I didn't think you would. June 27, 2025, 2 p.m. All right?
Thank you.
Thank you. Strong Future Homes versus Chanel McFarland.
Jillian Inges for plaintiff.
Hello.
Hello, we meet again.
What's your name?
Chanel McFarland.
Thank you. All right, where are we on this?
Your Honor, I have a balance including court costs of $6,817. I understand that Ms. McFarland is contesting it. I think that I haven't been able to take a closer look at the ledger, so I
Okay, so there's that.
can't speak to the claims on it.
All right.
But we'll look at it and hopefully.
Go ahead, man. What did you want to tell me?
Well, I was in court, this last November for the same case. My son had passed away, so they dismissed the case. But my legal aid attorney that I had, asked them to figure out how much was owed because I didn't owe them all of that. I did, put in an answer form to the clerk. I have pictures of the repairs that needs to be done and the repairs that, excuse me, that I have done.
Okay, the legal service is going to represent you at this point, do you know?
He's he's out the state this week. He did send me Alex Henry.
Okay, did he say he was going to represent you?
Yes.
Okay, let me do this then. June 27th, 2025,
There, that looks like a coffee
2
filter.
p.m. Okay, get back in contact with Mr. Henry and let's try to get that sorted out where we're going to.
All right. Thank you.
Okay, thank you. Strong Future Homes versus Catrice Hadley.
Inges for plaintiff.
Good afternoon, Your Honor.
Good afternoon. What's your name?
Shatrice Hadley.
All right. And what's the claim on this case?
I have a balance including court costs of $2,108.
All right. And the notes from last week said you were going to have it paid in full by next week.
Yes, so I have a check that I'm prepared to endorse to them today for $1,000, and my refund check is supposed to be deposited any minute now.
Refund from
School,
where are you in school?
Henry Ford College.
I don't know then. All right. What are you studying?
Social work.
We got enough of those. All right. Okay, so you got your refund check coming in. You have $1,000
Okay.
now.
Yes, sir.
Okay, but I don't know. They can't take a third
Okay.
party check, probably.
Your Honor, I don't know what the negotiable instruments do anymore. I think probably since it's gonna be adjourned for 2 weeks, Ms. Hadley, if you could maybe.
I can go cash
Yeah,
it.
You
Yeah.
cash it or.
Cash
Yeah,
it.
that's fine.
Okay.
That's fine.
Yeah,
Then here's what I'll do. I'll adjourn it to June 27, 2025 at 2 p.m.
That works for me. Thank
If you get that $1,000 into them and then and your refund comes through, then you get it paid, then you don't need to be here then.
Yes, sir.
All right?
Okay.
Okay,
Works
thank
for
you.
me.
How are your grades?
Really good.
Really good? Okay.
I'm proud of myself.
You know, when
45 and back in
you see
school.
the smile on their face? Oh, yeah.
I'm doing great.
Fantastic.
Thank you.
All right, you take care. Strong Future Homes versus Candace Long.
and for plaintiff, Your Honor, defendant Anthony Long was here earlier. He had to go to work. He says he's going to pay the balance in full on, I think it's Monday. Obviously, that's within the 10-day period. I told him that if I told him that I would ask the court for a judgment, but we would set it aside if paid in full honor before June 3rd, 2025.
All right. So what is the claim?
The balance rent to retain possession is $717. Court costs are $222 for a total of $939. The redemption date is June 23rd, 2025, and it will be set aside if paid in full honor before June 23rd, 2025.
All right. I'll issue a judgment for possession. I'll do it by default. Redemption amount in the amount requested with the rich issue in 10 days. That will be set aside if it's paid. All right. That one. Go back through these.
Okay.
Nope.
Oh, I went the wrong way.
What'd you say? Let's see who I want to call. Let me call this one. Strong Future Homes versus O'Day.
Jillian Egan, Pittsburgh.
See, I'm gonna make you wait.
Good afternoon, Judge Simpson.
Good afternoon. What's your name?
I'm Lolita O'Day.
All right. And what's the claim in this case?
I have a balance including court costs of $909.67.
All right. So Day, how are you gonna get that paid?
I talked to Hawk and I'm waiting on my SER, but I was just at court, it's $800 and some dollars. Like, I don't know. This
It
is
looks
from
like
20,
it looks like a late fee might have been added.
this is from 2023, Your Honor.
Okay.
I mean, I don't know. They never told me nothing until now that I owed it this back money. And I just got
Okay.
to
Do you
talking to
think you
legal
don't
aid.
know it? Or
I don't know. I can't even remember what I ate in March of 2023, Your Honor.
what you ate in March 20?
I don't know.
If you could even remember that far back. Because what was this morning? What did I have this morning? See, that's as far back as I can go.
That's why I'm in court for 2023. I don't know. I just got my ledger from Tanisha. I got all my
Okay,
papers.
so
I don't
did you want somebody to help you go through that? Did you want to talk to legal services
Yes.
about going through that?
Yes, sir.
All right, so here's what I'll do. Let me adjourn it June 27th, 2025 at 2 p.m. That'd be an in-person hearing. Get with them, go through the ledger. Let's try to figure it out.
Okay, he said June
27th.
At what
That's
time?
at 2 p.m.
2 p.m. Thank you, Judge Simpson.
You're welcome. Now you take care.
I'm at.
What'd you
I
say?
will, thank you.
What'd you say?
I said I will. I will take care of this.
Okay, you have a great weekend.
Yes. you too.
All right. Did I make you nervous?
True. Yes.
Wow. Wow. Oh. You did not have to sign on to what she was saying.
When a person ain't never been through none of this, Simpson, you know, I watch you a lot, and you're very, very, very fair, and I love that.
Thank
But
you.
I don't know, I'm just shaking.
No, I got you. Thank you for saying that. I appreciate that. Turn around and tell her that. Sparrowwood Apartments versus Regina Agnew.
Jillian Aiken for.
I was gonna make her wait to the end.
Oh,
But
I thank you. God is good. I thank you because I want to go to work. I said, Lord, if you let me be out of here by 1:30, I don't have to call off because I need the money.
you are just gonna hold church up in here, aren't you? All right. What's your name?
Regina Agnew.
All right, thank you. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $1,504.90.
All right, Miss Agnew,
It should
how
be-
are you intending to get it?
I talked to Robert G earlier, well, this morning about 10ish, and I went on the portal because he straightened some things out for me where I can go in, and I paid $200.90, which came out to $206.91 because of 2.99%. That's a lot of extra
Okay.
money. $6 is a lot in this economy. But anywho, to make that payment, I had stated to him that on the 20th, I would make a payment again, and I will be all paid up by the 27th. So on next Friday, I will make a payment of $550 and the remainder on the 27th.
All right,
Now, what I would like to say is, I understand business is business and they need their money. When I moved in the end of March, 6 days before the end of March, my door is, how would you say? I would say jimmied by the maintenance person, the sliding door, where if someone really wanted to get in my home, they could. And if I could just put it in escrow so they know that, okay, I know it's business, you bringing me to court. Yes, I owe you this. Yes, I do. But please make sure that my living quarters are good per the state guidelines as well, because they told me that it would take the guy that came out and measured the door. You can. The gentleman that came out and measured the door said that they had been telling them, Empire Management, with the prior tenants that lived in that particular unit that I'm in now, that they would need to replace the door. And the door has not been replaced yet. And today is, June 13th. Thank God I'm not superstitious. And it has not been replaced. So to be fair,
you need the door replaced.
I need that door replaced. I haven't been holding funds because of that. It's just other things that's been going on. And I just returned back to work on this past Tuesday due to.
What do you do for a living?
I'm in the auto industry, 26 years. Auto industry. Yeah, I know they say, oh, why she in court? To all the
No, I didn't.
not you, Your Honor, but to all the because there's some people out here that watch this landlord tenant stuff that don't work and they just want to, such and such was in court because they owe for this, but it's real out here. And mental health is real. I have lost people, but I'm saying this for the viewers too.
Oh, so now you go ahead, girl. You know what? I cannot stop you. Just go ahead. I figured she wasn't talking to me, so go ahead.
No, you good. You're right here. You're right here with me. You're right here with me. You just make me nervous. Well, I have to keep going back to the bathroom while I tell my neighbor. If they call my name, please tell them I just went to the restroom. But I haven't been holding money due to what they owe, but they're coming down hard on me. So since we're going to be hard about it, please take care. You shouldn't even okay for me to move in when I did and things was not taken care of. That's all. That's all I'm saying. But I will have this satisfied by the 27th, and I look forward to seeing you. If I have to come back in here in court, I hope not, because my shift started at 2:30, and I don't have to call in because God is good, because I'll be out of here. But we as people,
you just let me know when you're finished.
But we as people in the auto industry, we go through things too. I just want the viewers to know. Yes, I thank God for my employment. I was able to raise my children up on it, but there is things that goes on in life.
Okay, all right.
Thank you, Your Honor. I appreciate you.
And you. Did you want to say anything, Miss?
Your Honor, don't know if I can follow that up. Dagny, is it the latch? Is it just not latching?
It's
Or-
what it is it's the sliding door, and so you know you have the door that latch, but the back side of it is a
Okay.
gap. Rodents can get
Okay.
in, so they put
Okay.
cardboard in there.
I see.
And they
Okay.
told me they ordered the door, it would take 6 weeks. So we're 6+ weeks out. And I just need communications, everything, like they tell me, and I agree.
Thank you.
But I'm not holding rent because of that, but
Yeah,
since
no,
we
right.
in here, let's have a conversation about it. Respectfully, respectfully,
Yeah.
respectfully.
Okay, did you want, you mentioned. I almost
What
don't
is
wanna
that
ask
on her
why.
head?
You want to put it in court as?
And I do.
What the hell? Jesus Christ.
All right, so you need to
Next
print-
Friday, I will come to the courthouse and I
Wow.
will put that $550 in. And the following Friday, on the 27th, I will pay the remainder. And I tell you, Your Honor, you will not see me out of good faith in July, because July will be on time.
Thank you, ma'am.
You're welcome.
All right,
I appreciate you. I do.
June 27th, 2025, 2 p.m. All right,
Okay, thank you.
you take care, and
All
know
right.
they'll make sure to
Have a
get
great
in the
evening.
door. Really? Oh my God. I'm tired now. Flomar Apartments versus Duford. Recall.
Jillian and her plaintiff.
Were they here?
I thought he was.
Okay. This is a recall on the case. They're not here. If you'd like to take a default, you may.
Your Honor, actually, I would like to request leave to amend. We have a 1 month
Yes.
quit, and I just
All right.
wanna,
Leave to amend. You're amending it to a termination action.
we'll probably include both counts.
Gotcha. All right,
Um,
leave to amend is granted. And I will then adjourn this out, give you time for service to June 27th, 2025
Thank you, Your Honor.
at 2 p.m. Thank you. That's it for that block. Let's get the video going. I'll come back. Court is standing recess. Everybody can remain seated.
All right, I'm gonna get the 2 o'clock, I'm sorry, the 1 o'clock people to call your name, speak up for me.
okay.
Sadie Armstrong, are you here? Sade, yes. Sade? Yes, thank you, I'm so sorry. Jordan Oren, are you here? Yes. Thank you. Angela Schmidt. Edward
Yes.
Woods, I'm in Zoom. Quantavia Standrit or Chris.
That was fun. That was fun, I guess. God. Oh well.
Welcome to the 14th District Court. I'm the Honorable Jay Citrus, and I'm about to provide to you valuable information regarding these current and other landlord tenant practices. This is the landlord.
My rights.
And you are here for a retrial. Your landlord has made allegations of claims that you should be evicted.
Landlord tenant all day long. Oh, I guess I could put my stream up in
After today, you will come back for an additional trial the case unless your landlord agrees to separate.
Hmm. Let's see. Yeah, what's up? I did put it up. I did put it up. Okay, so I got that and that. So then I should be able to go straight up from there. Hold on. Back to the
In these proceedings, you have the right to have your case heard in the proper venue. 14A District Court is located in Pittsfield Township, Washington County, State of Michigan. 14A District Court also holds jurisdiction over the following cities, villages, and townships. In essence, anything in Washington County outside of the city of Ann Arbor and Ypsilanti Township is covered in this court. You also have the right to demand a trial by jury. If you want a trial by jury, you must demand it formally at the first appearance or in writing 5 days after the first being advised of these rights. Jury will be paid when the demand is made or within 5 days after the first being advised of these rights.
Stretch that up. Maybe.
You have the right to rental and
maybe.
other housing assistance. Within 5 days of the first receipt of these advice and rights and information, you must provide written proof to the court that an application for assistance has been submitted to the process. Housing assistance and rental assistance may be obtained through the Department of Health and Human Services, commonly known as DHHS. They can be reached at their phone number of 1-877-696-6775 or through mibridges.mich.gov. Assistance may also be obtained by contacting Housing Access for Washington
So
County,
there's that.
commonly known as HAWK. HAWK can be reached at their phone number of area code 734-961-1999. Additional assistance is also available through Washington County
Create a
Veteran
cone.
Services. Their phone number is area code 734-973-4540. Also, you may obtain housing assistance and other resources through coordinated entry resources. Their phone number is 734-546-748. You do not need a judgment to obtain assistance from any of these agencies. The sums of the complaint are sufficient.
So if I create a sketch there.
To reach an agreement outside the court, the Michigan and local community dispute resolution programs are a possible resource. The Washington County Dispute Resolution Center can be reached at their phone
Offset
number
that.
of area code
3, I guess.
794-2125.
Set that the other way, maybe.
To protect your credit and future rental possibilities, your case may be resolved by way of conditional dismissal.
Set it this way,
If
maybe.
that is approved by all the parties in the court.
Go that way. No, it's gonna drip on it now.
It is important that you understand these rights. If you have any questions, please feel free to address the court during your
Well, let's go out. Three. Looks good. Shut all these bodies off. This the base one. Oh, I guess I can edit that. Put some points in. Okay. Mm-hmm. It's odd. That was odd. Interesting. Let's do this then. Go. So there's no Simpson. Just me. Turn some music on, maybe.
In Australia, g'day's the start of every good adventure. Yep.
Listen to this music before Judge Simpson comes back on, I guess. Oh, he's gonna be joined. Oh, Simpson's back. Let's go back to Simpson.
You may be seated.
Back
Court
to
does call the
Simpson.
case. Jeff Lewis versus Michelle Kresnak.
Both Jeff and Julie
The
Lewis.
judge is
here, they just
back.
temporarily stepped out. If you'd pass it for a few minutes until they return, thank
Couple
you.
minutes, sure. They're coming in now. All right. Go ahead. We'll go ahead on it.
Oops, sorry.
Daryl Barton appearing on behalf of Jeff and Julie Lewis.
Michelle Kresnak?
I am here.
All right. Okay, this is a termination of tenancy case. And basis for the termination?
They have violated the lease. They have not made any payments since February, and the outstanding balance is $9,851.15.
But there's a lease covering the premises.
That's correct. We'd like to ask to, if need be, leave to amend the complaint to include Noah Brush, who apparently has been living there the whole time, and is just the electricity was, he claims to be the main tenant. The electricity was cut off and they added his name.
So, well, we've got a problem here. And the problem relates to the notice to quit. Because the notice to quit is terminate the tenancy, but the claim that you have is basically a rent claim.
It's actually including in the lease. I asked that we had a supplemental judgment on that, but the lease, well, my glasses
I
here.
don't think that you can do that though.
Okay,
If the claim is for not paying rent, then one would have to.
No
file a
rent for
non-payment
you.
of rent
it
action.
says under the lease, the lessee agrees that the lease agrees that the lessee's failure or refusal to perform according to the terms of this lease agreement will allow the lessor's option to terminate this lease and begin eviction proceedings. That's specifically in the lease.
I don't doubt that. But it can't be terminated like that. It just, there are two separate sort of avenues. One being a non-payment of rent, one for others, non-payment of rent, and then termination of tenancy as a whole without the option to redeem. When it's a non-payment of rent, part of the remedial measures is that the tenant has the ability to redeem. And so I don't know that I can do much with this case. Because along the lines that you're asking me to terminate.
File a 7-day notice to quit.
That's what's gonna have to end up happening. I don't think based upon this that the court has subject matter jurisdiction over the case for the reasons that you stated. So, and when that happens, the only remedy I have is to dismiss the case. So I'll dismiss this case for lack of subject matter jurisdiction. And then we'll await your
Thank you.
arrival back here. And with reference to that other issue, could you see Miss Widling? We figured it out on
The other case.
the other thing that talking about the execution.
Yeah.
Okay.
Is there something I need to see her about?
Pardon?
Is there something I need to see?
Yeah, if you talk to Ann, she'll update you on what we found out. Barnes and Barnes versus Contavious Scandrett.
I was speaking for the plaintiff, Your Honor.
And also Christopher Mayo.
Mr. Mayo made representations the last time that he was going to get us paid fully.
Yes. And has not.
He is not. And he's not here, and so I'm going to raise my
your
right.
right hand. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead, sir.
We checked the ledger as recently as about 45 minutes ago, and the number is for rent is $2,335.34. That's 2335.34. $250 in costs for 258534.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
And if he pays it within the 10 days, I'll set it aside.
That is all right.
Thank you, Your Honor.
Thank you, sir. Ridgewood Apartments versus Amy Wisner.
Philip was 25.
Good afternoon, Your Honor. Mark Schlesinger appearing on behalf of plaintiff.
Hello.
Hello.
Your name?
Amy Weisner.
Okay. And how much is owing on this currently?
Judge, with court costs, there is presently $5,460.87.
And how are we going to get that taken care of?
I'm still waiting to hear back from SER. I talked with Hawk and they are out of funds right now, but they have me on their list. And I'm working with family to try to secure anything and still interviewing for jobs. I lost my job in December. I lost all my income source in December, right when I moved in. So.
All right. So the problem that we're going to have here is I've given the adjournment for the filing of at least a claim that you're seeking assistance.
Mm-hmm.
I don't have anything. There's not a dispute at all as to what's owed. So what I'm going to do is I'm going to issue a judgment finding no tribal issue in your hearing. I'll issue a judgment for possession and money in the amount paid for $5,460.87.
I go 6 by 28.
What I will do, since you're waiting on Hawk and I'm not sure where they are, the normal writ date would be the 23rd. I counsel over the objection to plaintiff. There's no writ until the 30th.
Yeah, the week ends on the 29th. So,
Judge, why would you assume I would have objected?
You're right. I didn't, but in case you did, I was taking a preemptive step.
Thank you, Your Honor.
Thank you. Thank you.
Judge, we'll submit that.
All right.
Bye-bye.
Bye-bye. Northfield Estates versus Tamara Coppins.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
Hello, your name?
Tamara Copens.
Tamara Coppins. I messed up the whole name, didn't I?
That's okay.
All right. What is plaintiff's claim today in this case?
Your Honor, let me
Oh, this is
verify.
actually her motion to set aside.
That's correct.
All right. And ma'am, what's your basis for setting aside the judgment?
I took a fall on their property and busted my kneecap in half. That was February 2nd, and I lost my job, a great job. I had just been approved. I worked for the Veterans Affairs. And I'm not quite sure I know what set aside means. I have tried to make payment arrangements with them. In fact, I even tried to make some payments, but I'm blocked to make them.
Well,
And
let me stop you there.
Sure.
This is a motion to set aside the judgment which you filed.
Okay.
And in order to, I'm not even sure how it got set for a hearing because escrow was not paid or bond wasn't paid on this, but that notwithstanding, there are two things that you have to show me. You have to show me that you have a meritorious defense to their claim for rent. And then the other thing that you have to show me is you have to have some good cause for your failure to appear back on May 23rd of 2025.
Yes, I can.
Okay, so why
I went to the courthouse, and it was closed in Saline. I'm on the summons, which I've never had before. It said appear to the court address above, and it said Zoom, but that box wasn't checked. I honestly thought that I would go to the courthouse, which I did do, and the judge would be on the screen. That's what I thought. But when I got there, it was shut down.
Yes.
And so then I panicked and I called, and the Northfield Estates told me, nope, you're evicted. And I'm like, what? And then I wrote a letter, and then the lady I was working with said, you got to fill this out. I filled that out. And I had no problem paying some money into an escrow. I didn't know about that. But basically, I've tried to make payment arrangements, but I feel strongly that they should work with me because this is on them. I mean, I didn't have to lose my job and fall. And so they should work with.
Ma'am, so let's assume I take that as a good cause. You're not disputing that you owe the amount.
I am disputing it in the sense that they should negotiate with me because I lost my job because of their mistake.
In what sense?
Negotiate that I don't have to pay the rent or pay some of it until I get back to work. And then the whole thing, because I literally fell on their property and lost everything.
I understand that, ma'am, but I don't know anything about that as to whether or not it's their fault.
I understand what you're saying, but I've given them all my medical records. They know. That's why I was surprised when I got the summons. Actually, my mom got it, and I'm glad I saw it because she doesn't have a great memory.
Ma'am, I don't know whether it's because of anything that the landlord did that caused the fall. And that would not be before me.
Okay.
So the real question is how are you going to get this judgment paid?
I've offered them to.
Because there's probably more owing now.
Oh, I'm sure that there is.
And Your
How
Honor,
much is owing?
the total that's due at present, Your Honor, is $2,902.32. And Your Honor, if I could just state my position with respect to the motion itself.
Yes.
I don't believe that Ms. Copens has good cause for her failure to appear. She indicated that she went to the courthouse in Saline, which understand the courthouse is closed for renovations. But there's no indication that Ms. Copens then called the court to say, hey, I'm at the courthouse, it's closed, what do I do? Instead, she waited until later that afternoon to email me and say, hey, can we reschedule this? I had responded and said, unfortunately, no, judgment has already entered, so the court case is not going to be rescheduled. And so I don't believe that she's established good cause for her failure to appear. That's number one. Number two, I don't believe that Ms. Copens has established a meritorious defense to the underlying action. Your Honor, whether or not there was an incident on the property, and whether or not Ms. Copens can prove that my client was at fault for said incident, I am not conceding, Your Honor, in any way, shape, or form that they are. I would dispute any claims that they are. However, that is separate and distinct from any obligation that Ms. Copens has to pay rent, which she has not done. And so for those reasons, Your Honor, I would have to request that the court deny her motion and allow the judgment to stand in full force and effect. And at this point, we are well beyond the statutory 10 days that was entered on the original judgment, and would request permission for plaintiff to submit an order of eviction in this matter.
I would like to respond if possible.
Go ahead.
I'm not an attorney. I lost my cell phone service because I have no money. And I have to go hook up to a McDonald's or something, and I'm using these silly text apps. I got in touch with, I didn't know who to call because the place was closed. And then when I would hook up, I figured it out and I made my calls to the court. I don't know if I emailed them first. And I have had no problem. And I've repeatedly said, do we have to go to court? Can I pay this amount and catch up every month? So it is as if they want my dad's house. My dad was a vet, and it's like they just want it. So I don't even know what notarious means. I don't think there's any doubt in Northfield Estates, but it's not for this court possibly, or it's clearly not, but I don't think they have any doubt of where I fell and why I fell. But I don't even care. I just busted my knee, never been in sports, never had that pain except for babies. And I lost a job at the NFPA.
Okay.
So why can I not make a payment schedule, like $1,000?
Ma'am, that's going to be something that has to be negotiated between the parties.
That's what I tried to do.
Okay. But if they don't agree to it, that means that you guys haven't come to an agreement on it.
Right, but they are now saying they want to evict me and my 83-year-old mom when the house has been in my family for 15, 20 years, and it's been paid every month because I didn't prove that there was a good cause. I didn't go to court.
Ma'am,
I'm
asking
confused.
the court to do something the court can't do.
Which is what?
I can't force them to enter into a payment plan.
Okay.
All right. I am here right now on your motion and have to rule legally on your motion. And I told you at the very beginning 2 things that you needed to show me: your good cause for your failure to appear, as well as a meritorious defense of the claim.
And both,
Frankly,
I've done one of those.
You have to show me both of those, and neither of those have you shown me.
I did.
Because we had gotten a call, and it sometimes does happen. I'm not going to dispute that somebody goes to the wrong courthouse. We get a call, we get something.
You did
that day.
You did
saying, "Ma'am, I don't have a record of that."
I
But
sent it to
even-
the court,
even if
and you
I
emailed me
did,
back.
Ma'am, don't overtalk me.
Sorry.
I'll let you go on. I'll let you tell me anything, but you're going to have to stop over talking.
Okay.
Even if you did, and even if I were to find that that's a reason for not appearing, I don't have a meritorious defense of the rent claim. I have to have both.
I don't have a lawyer. I wasn't told that, nor do I even know exactly what that means. So bottom line is they want $3,000, or what? How much does she want?
It would be $29,0218, but if you pay $22,3479, that may stop the eviction.
I'm very confused. I talked to this court. I spoke to this court. They emailed me back and said, Judge Simpson has set this aside. You're going to go the 13th. So you're telling me to show you something that
told you that.
I have my phone. I have your emails. I have it from your courthouse. Maybe not you directly.
I can.
She's been copied.
I've seen the email chain, and there may be some confusion. The 14A4 civil clerk did send an email on June 2nd stating Judge Simpson has granted your motion to set aside default. The motion hearing is set or scheduled for 6/13/25 at 1 p.m. This will take place in person at the 14A1 District Court and provided the address. Have a great day. Ms. Copens forwarded that email to my firm on June 2nd. I then reached out to the 14A4 clerk and I said, the tenant forwarded our office the below correspondence.
Oh, well.
I asked for clarification as to whether or not the motion had been granted or if the court had simply granted a hearing on the motion.
Your house.
Civil clerk indicated judge has reviewed the motion and set it for a hearing on 6/13.
Nobody cares.
25 at 1
Oh,
p.m. And I said,
well,
so the motion is granted.
Whatever.
Is not granted, just set for a hearing. If so, that may need to be clarified with the tenant because I believe that Ms. Copens was under the belief that the judgment had been set aside. Not
well,
that
I'm going to go have some lunch, I guess.
granted, or motion hearing had been granted. I
See
did
y'all
correspond
later.
with Ms. Copens after that and explained to her that no,